All right, on this True Law Stories, I have Steve Williamson returning, talking about almost $6 million verdict in a slip and fall case in Queens, New York. We're going to talk about how they almost lost it, about how they prepped for trial, how a lot of people, including this person, didn't think they needed to sue, how the accident happened, why the insurance company ran them through the ringer, and ultimately what was the key things that helped them to win the trial. All this on True Law Stories, but of course this is brought to you by videocasestory.com. One of the best places to share your business's story is through Video Case Stories and on YouTube. If you want to get started on YouTube, go to videocasestory.com/planner. We'll tell you exactly how to plan a year of YouTube that gets you results. All right, let's get started. Steve, thanks for being back on.
Happy to be here, Ian. Great to see you.
Steve today is going to talk about another trial, another case that went to trial, a slip and fall case, again with a spine accident, and we're going to get really into just how the trial went, the jury prep, everything. But Steve, before we get started, let's just start. What happened? What happened to this person?
This particular case, I represent a woman who was 38 at the time. This happened back in 2018. She was a mom, and she worked at a Spanish restaurant in Long Island City, which is a neighborhood in Queens. And she was married, and she lived in an apartment building in Queens on the 4th floor. It was a big apartment building, but there were no elevators, so there's staircases for people to go up and down. And on September 3rd of 2018, it was actually Labor Day, so everybody's home, nobody's working. She was going down the stairs to go to the laundromat that was down the street. She was in the process of doing her laundry, but she just had her phone and her keys with her. And the super that day, even though it was a holiday, had been mopping the floors and mopping the stairs. So the stairs were wet. He acknowledged later in a deposition that he had mopped the stairs just before she came down. And so the stairs were wet, and he didn't put up any signs. There were no wet floor signs, there were no mopping signs, and he wasn't there in the area where she was when she came down the stairs. So she comes down sort of the last flight of stairs before the first floor, the landing, and the stairs were wet. She didn't know it. She slips as she's sort of at the top of the landing going to the first step down with this flight of 7 stairs to the next level down. Her foot slips out. It slips out, pretty fast and hard. So instead of her falling forward onto sort of, her hands in her chest, her leg goes out and she sort of flips backward, and she falls on her back and her neck and sort of bounces down this flight of stairs, these 7 steps. And they're hard stairs. These are like marble, hard stairs, no carpet or anything. And she lands all the way at the bottom. And she's hurt. She's immediately hurt. She's got neck pain. She's got back pain. She's not able to get up. One of the neighbors hears the commotion, comes out. Her husband, who's upstairs, is called. The super eventually comes out, and the EMTs are called, and she's treated at the scene and taken to the hospital. And that's sort of the beginning of the case. It's a slip and fall on wet stairs in an apartment building where my client lived.
Now, sign's not there, wet floor, wet stairs, marble stairs. It seems pretty obvious that that there's a problem there, right? And it seems pretty obvious that, the liability is to the apartment building and apartment owner. Why was this a case?
Why was it a case that was fought for years?
Yeah, why was it a case that was fought? Why didn't the insurance company just pay the money to take care of her?
Well, a couple of reasons. Number one, as much as the liability seemed pretty clear from early on, we had to do discovery in the lawsuit before all, those facts came out, meaning that it wasn't immediately apparent what the super was going to say. The fact that he was mopping, the fact that he acknowledged that there were no signs, that didn't come out until we brought the lawsuit, and he was deposed. He testified in a deposition, and he acknowledged that. And a lot of times witnesses don't acknowledge that. They'll say something that's untrue. To this guy's credit, he did acknowledge that he was mopping and he didn't put up a sign. But early on in the case, number one, the injuries sort of take time to develop, because for her, like a lot of my clients, early on, she sort of had the hope and expectation that she was going to get better. Either she was going to heal naturally or she was going to respond to the treatment. So it takes time for someone to recognize that they're not getting better, that there may be an ongoing effect or later sort of a permanent quality to the injuries. It takes a while for someone to sort of face the unhappy reality that they're not responding to conservative care, that they have to kind of go up the treatment ladder and have more care than they originally anticipated, that they're not able to get back to work speedily like they initially expect. People are optimistic. They think, yeah, I got hurt, but I'm going to get better. I'm going to bounce back. Nobody expects at the beginning for it to be a serious or a lasting thing, unless it's like a truly catastrophic injury that's evident right from the outset. So that, there's a number of factors, but another way to answer your question is, even though the liability became pretty clear midway through the lawsuit, the defendant and its insurance company still fought us. They fought us all the way to trial, and it wasn't until literally days before we were going to start trial that they kind of conceded liability and acknowledged that they were at fault and said, we're not going to fight that part of it. But there was still a big fight on the damages, the severity of her injuries and their connection to the incident. And we ended up trying the case over a month, and the whole fight at trial was about them refusing to acknowledge that her injuries were serious and that they were caused by this incident. They really fought her and attacked her over that.
I want to make a point here, just because I think it's an important story, but also that, because I talk to so many people that, we massively underestimate how many accidents happen in the world, and people just don't talk about it, and they're like, oh, I'm not that hurt. And I hear this all the time, because I'm not an attorney, but I'm like, you need to talk to an attorney. And they're like, well, I'm not that hurt. You see this a lot where like the injury doesn't seem so bad at first, right?
Yep. Happens all the time. Whether someone injures their hips, their shoulders, their knees, their neck, their back. A lot of times with injuries like that, the effect, how the injury develops, how the symptoms develop, is not immediately apparent to the person. Oftentimes people, whether it's a car accident or a fall down, because the inflammatory response in the body takes time, hours, sometimes days to develop, people will often not feel that much pain or even any pain at the scene of an incident, and not until hours later or when they get home that evening realize, wow, I'm really in a lot of pain. And sometimes it's hard to memorialize what happened if you walk away from an accident, whether it's at a store or in some kind of premises or on the roadway. And then people are in a difficult spot because now they realize they've got a problem, but things weren't really documented right at the outset. And that also happens days and weeks later. People think they're okay. They don't want to make a big deal of it. They don't want to be a complainer. They're not the type of people who think about suing. They want to get back to their lives. They have busy lives. And it's not until days, weeks later, they realize they've got a problem. And then, it can be hard to put the pieces of the puzzle together because, evidence disappears quickly.
I want to put a caveat, not a caveat, but just emphasis on this, folks. Whoever's listening to this, because I literally was just talking to a family member. Steve mentioned it's the holidays, and I saw her, and the last time I saw her was a few months ago, and she had a slip and fall, and I'm like, you need to talk to an attorney. She's like, well, they're taking care of me, because it was at work, and I'm like, they're taking care of me. I'm like, but you have a severe injury, and you just talk to an attorney. And luckily she did, because she's like, they were starting to refuse treatment, right? And if she would have just signed off on it, she would have had no. It's a difficult scenario, and it costs nothing to call an attorney, and you get a good one. And the good people are going to say, they might say, hey, just see how it's going. Let's get the information, because also you don't know if the information is going to disappear, right? Because, like you said, people cover stuff up.
You don't really have someone who's truly on your side unless you have a lawyer. If you get hurt at work, your employer or their insurance company, ultimately they have a different agenda. They have different interests that are usually contrary at some point to the employee's interests. If you get hurt in any kind of context, the only person who's going to be truly on your side and looking out for your rights and not have a conflict of interest is your lawyer. And you're also 100% right. evidence disappears, witnesses, become hard to find or, are uncooperative. You have to move swiftly to make sure the evidence is in place, and this way you're protected. And if you get better or it ends up not being a big deal, you just tell the lawyer, I'm okay. I don't have to pursue this, and everybody's happier. It's much better to not have a case and not have an injury. But if, God forbid, you're in a situation like that, you want to make sure your rights are protected, and at least you have the option and you have someone that you can talk to who's on your side.
Yeah, it's critical. It's just covering the insurance basis. And I think that I just want to stress that because I have so many stories of this, folks, and it's not because I do the interviews and I see this all of the time, and most people, the insurance companies have done a great job of saying good people don't sue. It's not suing; it's protecting yourself. So tell me a little bit about when this woman came to you, like what was going on and what did she say?
Well, a lot of the cases that I handle, I'm working with other law firms who represent the client from the outset, and I come into the case later as trial counsel, sort of in the latter stage of the litigation as the case is nearing trial. And I'm the guy who comes in and prepares it for trial and then takes it to court if the case can't be resolved. But when I met her, she was still out of work. She was really struggling, not able to resume the life that she had before, living with chronic pain in both her cervical spine, her neck, and her lumbar spine, her back, really impacted in all the aspects of her life. She had a young daughter sort of later in the story of the life of the case. She was really struggling to meet the demands of being a mom and was really impacted by that, both physically in terms of her capacity and emotionally in terms of the toll that was taken on her. She was having terrible difficulty sleeping. Sleeping is often a huge problem for people with spinal injuries. She was exhausted all the time, and it was kind of what she described to me was sort of like a double whammy of not sleeping well at night because of waking up with the chronic pain, especially the tightness and the stiffness that would happen in her spine when she was still trying to sleep in the night, and then really struggling in the morning to get going, and then having sort of the extra exhaustion of living with pain all throughout the day. And she said to me at one point, I never realized that living with pain was so exhausting. And so what we were able to sort of unpack as her truth when we spoke at length was that she just, even though she's a young woman, she's in her early 40s at the time the case goes to trial, she really described feeling like an old lady before her time. And a big part of that was being so exhausted, not sleeping well most nights, and then being physically depleted and physically exhausted from the extra toll of living with pain during the day. So, she would describe as soon as she laid down, she'd be out. Her head would hit the pillow and she'd fall asleep. But then within a couple hours, she'd be waking up with a problem in the middle of the night. And this wasn't occasionally, this wasn't a couple times a week. This was sort of her nonstop reality. So she was really struggling with a lot of permanent effects that were very, very impactful.
And so when you were brought in, did you know this was going to go to trial?
You never know for sure, because just like we don't disclose to the other side what our negotiation tactics are and what our sort of true aims are with respect to trying to resolve the case, the defendants, the insurance companies, the self-insured entities on the other side, they do the same. They're not going to lay their cards on the table. And sometimes there's a lot of misdirection and games that are played legitimately in the negotiations that go on. So you never know for sure whether a case is going to be able to be resolved in the months before trial, the weeks before trial, or right on the eve of trial. But our approach is to be ready on every case. And my philosophy is the best way for me to get a great settlement, not a good settlement, but a great settlement for my client, is to be ready for trial, to be ready to go to court and fight and win. Because it's really no different from anything else in life. If you're going to get into a battle or fight with someone on the other side, and they see in the run-up to the battle that you're training hard, you're getting ready for this battle, you're getting up early every morning and training and eating your spinach, and you've crossed all your T's and dotted all your I's, they're going to be less likely to want to get in the ring with you because they're going to realize that you're ready not only to fight but to win. And it's the same thing in litigation. You have to show the other side that you mean business. And if the case settles, if they recognize the legitimacy of the case, that the just result is a resolution for the client, great. If they don't, we're ready to go to court and fight and win.
And tell me about, like, it's going to go to trial. Tell me when you knew it was going to go to trial and how you prepared for it.
Well, we get a trial date from the court weeks, really months in advance. And then as you're getting closer, it becomes more and more real. We do a ton of trial prep. We spend an enormous amount of time in all aspects of the case with the witnesses, with the records, with the evidence, with the presentation, with the visuals, with everything that we're going to present and do in the courtroom. So there's a lot of work that goes into it. And then the trial starts. And every trial is different. And the thing is, there's so many variables in a trial. You don't know how the defense lawyer is going to be and what he's going to say and what tactics and strategies he's going to use until it starts. You don't know what kind of jury you're going to get until you start selecting those folks and putting them on the panel. You don't necessarily know in New York who's going to be the judge until shortly before a trial. So you don't know which courtroom and which justice you're going to be in front of because every judge is different. So there's a lot of variables, that come together at the last minute.
And tell me about preparing, the plaintiff for trial, because they're going to have to get up on the stand, and it's not easy, right? But you have to prepare for this.
I think for most, if not all of my clients, and I think this is almost entirely true for any person who's a plaintiff in a high-stakes civil lawsuit that goes to trial, testifying in court in front of a judge and a jury, not only answering questions on direct examination from your lawyer, but standing up to cross-examination in an effective way from the other side, from the lawyer whose job it is to take you down, is a very difficult thing for anybody to accomplish. I think it's hard for a professional to do. I think it would be hard for a lawyer to do. For a layperson who's never been in this environment, never been in this setting before, who's doing all of this for the first time, where all of this is new and scary. And add to that, Ian, that the stakes are so high for the client. Oftentimes, their whole life, their whole financial life, their whole emotional life, their whole family life, their ability to have the resources to care for themselves, get the medical care they need, to have the freedom to recuperate and recover and rehab in a legitimate way, to take care of their family. All of that is on the line with the lawsuit, and all of that is pressure that they feel when they have to testify. So it's a big deal for them, and it's hard. And so the way we address that is we spend an enormous amount of time with the client, walking them through all the aspects, everything that's going to occur. And a big part of my job and the job of any successful trial lawyer is to anticipate what the issues are going to be, not just obviously when I'm asking the questions, but what is the defense lawyer going to ask? What are going to be the areas of attack on cross-examination? If I can do my job and anticipate 95% of what's going to come up, I can go over that with the client beforehand so that nothing's coming out of left field. Because even if, it's something perfectly legitimate and they're telling 1,000% the truth about whatever that thing is, if they haven't been prepared for it, if they haven't had a chance to think about it, if it's coming in real time in the courtroom for the first time, it can be hard to field that question. So the preparation of the plaintiff is a huge, I would say, the biggest piece of the puzzle. And the other reason for that, Ian, is in this case, like most personal injury cases, as much as there are a lot of facts and issues and witnesses in play, the case more than anything is a referendum on the credibility and the character of the plaintiff. And in this case, like so many cases, the standard playbook of the defense is to attack the plaintiff as someone who is exaggerating or falsifying injuries for the purposes of trying to get money in the case. The defense isn't stupid. They know that their best friend in the courtroom is the ugly stereotype that is pervasive in our society, that there's too many lawsuits out there, that people are too quick to sue, that the system is broken, that most injury cases are exaggerated or outright fake, that most personal injury lawyers are willing to say anything to win a case, to get the money. And I think some of that is made worse by a lot of the advertising that plaintiffs' lawyers do. Some of that advertising isn't the most, some of it can be a little bit crass and go a little bit too far. But the majority of that sentiment comes, and it's no coincidence, it's not something that happened by happenstance. It is propaganda that is intentionally put out there by the insurance company to make people think that most injury cases are exaggerated or puffed up, aren't legitimate, because they know if that idea is in people's heads, it makes it much harder, if not impossible, for legitimately injured people to have their day in court in a fair way. It makes it so much harder for their lawyers to present the case and get a just verdict, because like any situation where people, start off with these stereotypes, it's uneven. People are walking into these cases with a certain level of suspicion that they have toward the plaintiff, even though the plaintiff may be the injury victim who did nothing wrong and is legitimately injured. They sort of start off under a cloud of suspicion that the defendant, who's the wrongdoer in the case, doesn't have. And so, there's a lot of those dynamics at play in these cases. And because we have to overcome all of that, the job of the plaintiff, in terms of testifying effectively, has so much to do with coming across in a way that is credible and believable. And you and I have talked before about our approach, or my approach, to being as brutally honest in the courtroom as possible, to be as forthright and as open, as transparent as possible with juries, so that you're laying all the facts on the table and you're trusting the jury in their own common sense and wisdom to get it right if you give them the information that they need.
And so the trial starts. You've done all this trial prep. It was a month-long trial?
With the jury selection part, it was a month. Jury selection took probably a week. And again, we're working really hard to find people who can be fair, who aren't leaning against the defendant from the start because they don't like landlords. There's a lot of people who rent in New York City and they don't like their landlords. And that might mean that someone like that would be starting off a little biased toward the defendant. And my approach in jury selection is I want a fair jury. I don't want a jury that's leaning toward the plaintiff right from the outset. I want people who are going to call it fair square right from the outset. And then there's a whole bunch of people on the other side who, for the reasons I just described, are starting off leaning against the plaintiff because they have this view right from the outset that injury cases are exaggerated, that it's all about money, and that someone bringing a suit like this will say or do whatever's necessary to try and win the case. And they're leaning right from the beginning against the plaintiff. They have a suspicion right from the start. So to weed out those people and get people who are truly neutral can take a while.
And so you had jury selection. How did you feel after jury selection going into the trial?
There's always a tendency to wonder, did I make the right choices, to potentially second guess. One of the things that was interesting in this case is once we started the trial, really from opening statements and through the 3 weeks of testimony, through closing, we were watching the jury, me and my team. Everybody in the courtroom watches the jury to some degree, but certainly the lawyers, the parties, really watch the jury to see if they can read some of the tea leaves. And during the whole trial, we were seeing in the demeanor and the expressions and the reactions of the jurors some cause for concern. In this case, and this is not true in most of the trials that I do, over the course of the trial as it unfolded, we were getting worried about the jury because there were several people on the jury who seemed to be having favorable reactions to the defense attorney and his evidence, his witnesses, and they seemed to be showing what looked like some skepticism or hesitation around our side of the case, our presentation of the case. And so as much as we recognize that trying to read the jurors' minds during the trial is a parlor game, you can't ignore completely the vibe in the room and the reactions you're seeing. And so that was a concern. And because of that, I spent a lot of time during the trial thinking about jury selection and thinking about the folks that we chose. Now, ultimately, we won the case, and we won the case big. And so after the win, both in speaking to some of the jurors afterwards, but also analyzing the case, I went back to jury selection, and I really thought about what lessons can be learned. I mean, did this trial mean that in future trials I should ignore the expressions, the demeanors, and the reactions of the jurors? No, of course, you always have to take that into account. But the lesson that I drew from this experience in sort of the contrast or the difference between the vibe that we were getting from the jurors during the trial and the verdict, which was positive, was that when you're picking a jury, one of the things that's important to be cognizant of is who's going to be a leader on your jury and who maybe is going to be a follower. Because the leaders are obviously going to be stronger personalities. They're going to tend to be more influential in the deliberations and the ultimate decision of the case. And it really reinforced to me, always be thinking in jury selection, who's a leader, who's a follower, and don't pick a leader. Don't pick someone for your jury who you think is a leader unless you're completely certain that they're going to be good for you. Because if you pick someone who's a leader who's going to end up being on the other side, that could be the thing that loses the case for you, because that leader could persuade the other jurors to see it his or her way. And what I realized in retrospect with this case is that we had picked two folks who at the time we thought were leaders. We were right. They turned out to be leaders on the jury. And in retrospect, their faces, their expressions, their demeanors were more neutral than some of the other jurors. And they were the ones, I think, in large part, that carried the day in the deliberations and were a big part of the verdict that we got. And so the lesson I took was think about all those things about leaders and jury selection. And if you've made good choices, even if some of the vibes and expressions during trial aren't the best, ask yourself, are those vibes coming from the leaders? Where do the leaders seem to be? And understand that while the whole jury may not look favorable all the time through trial, if your leaders still seem to be open to the case, there's a good chance you're going to get a just result. I don't know if that answered your question, but that was a big part of what we experienced and what we kind of learned from this particular trial.
And when you're doing a big trial like this and you're going into this and now you're in the middle of trial and you're sensing these things from the jury, how does that affect what you do during the trial?
I don't think it changes your strategy or your tactics, but I would be lying if I said it doesn't mess with your mojo sometimes. You know, when you're up there asking questions of a witness, but I think more during things like opening statement and closing statement. You know, if you're delivering a closing statement, lawyers are human beings. So if you're up there giving a speech and you feel this positive vibe from your audience, from the jury, you see people nodding, you see people following, that's going to feel good, and it's going to add to your confidence and add to your ability to be dynamic. If you're getting an opposite reaction, that could affect how you present for the rest of your closing or whatever it is. I think that's where experience really comes in. If you've been trying cases and in these situations for decades, you have the experience to know, number one, what you're feeling in the moment may not be, the overall and may not be entirely accurate, but you can soldier through. You can stick to your game plan. You can stick to your presentation. You don't miss stuff. You still deliver stuff effectively in the way you intended, even though you may be, because you want to be watching your audience, maybe not getting always the reaction that you want. But it's challenging. there's no doubt that it's challenging. And I think any lawyer who tells you different, is blowing smoke.
Okay. So Steve, tell me about what was the big, what was the problem? What was the, insurance company and the insurance lawyers saying about this plaintiff that they thought was wrong?
The defense in this case was pretty much a standard defense that you see in a lot of cases that we see day in and day out from the insurance companies and the lawyers. They did not want to acknowledge her suffering. They didn't want to acknowledge the seriousness of the injury. So they attacked her credibility. They tried to suggest, and I don't think it was fair, I don't think it was right, it wasn't really a legitimate interpretation of the case or the evidence, but they tried to say that she wasn't forthright about her medical history that predated the accident. She had neck injuries, she had back injuries from this, but this was a woman like a lot of people in life. She was 38 years old, and she'd had some back pain, she'd had some visits to the doctor, she'd had a car accident in 2006, so she had a history with respect to her low back, and she was pretty much forthright about it, although she didn't remember all the details when she was questioned in her deposition. And they attacked her, one, by saying she hasn't been honest about her past, because they were trying to bring her down and get the jury thinking this is someone that you can't trust, this is someone who fits into that stereotype of an untruthful personal injury plaintiff. And then the second part of that argument was none of these injuries are related. None of these injuries were caused by the fall, even though she got immediate medical attention and the ambulance report and the ER records showed immediate complaints of neck and back pain. I mean, the injuries were there and apparent and documented right from the beginning. But they refused to sort of acknowledge that, and they said it's all pre-existing, it's all degenerative, it's all from age, and don't trust her because she hasn't been truthful. That was sort of the two-pronged defense, and they peddled that all the way through the trial. And fortunately, the jury saw through that smokescreen and got to the right result and made a just verdict for her.
And what was it like, and she was also pregnant during this trial?
No. She had had a baby. She'd had her daughter in 2021 during sort of the life of the case. And it was a relevant fact at trial for reasons that we could describe. But she was very much a mom. She had an older son from years before. And by the time of trial, she had a 3-year-old daughter.
And how does that affect the case?
So one of the things that we're always concerned about is that if I represent a woman who is asserting that she's got a debilitating or disabling or serious injury to whatever that injury may be, if there's a pregnancy and a birth during the life of the case, meaning after the incident happened but before the case comes up for trial, there's always going to be a question about how jurors are going to react to that. Because what I've seen over the years is jurors will often sort of jump to the conclusion, if this person is seriously injured, if this person is disabled, if this person's life and activities are impacted in a significant way where they can't do this and they can't enjoy that, how are they at the same time conceiving? How is this woman, whoever she may be, getting through the physical rigors and the physical demands of a pregnancy? How is she getting through the physical stuff that's involved in raising a young child, which you and I both know is substantial? Also, on sort of a symbolic level, a pregnancy, the birth of a child, is an occasion for joy.
So how did you, real quickly, how did you fight that? What it was like waiting for the verdict and hearing the verdict?
Sure. Real quick. We were concerned that the defense lawyer was going to make a thing about the fact that she got pregnant and had a child at a time when she was suffering with the injuries. We knew their doctors were going to make a thing of it because they mention it in their reports. And I knew that if I just mentioned it or tried to excuse it or worse, ignored it, it was going to become a big problem. And so I spent a lot of time talking with her. And what we were able to unpack in our preparations was that her and her husband were a couple who had been trying for years before the incident to get pregnant. for, I think, 4.5 years before she got hurt. They had been trying unsuccessfully to have a child of their own because her son was from a previous relationship from before. And what she, and I'll say this briefly, she basically described that because of the injuries, their effort to have a second child or to have a child of their own basically was abandoned. They basically gave it up, and their times having intimacy dwindled to next to nothing. But it did happen occasionally. And so what she described is that in 2021, when she got pregnant, that it was almost one of those sort of funny ironies of life, because they had been trying regularly for years and it didn't happen. And then when they were barely having relations at all, she gets pregnant. And she was able to effectively describe the range of emotions that she had, that she was surprised that after all this time, and especially now of all times, that she actually conceived after failing and trying for so long. But also she was excited because this is a thing that they wanted to do for so long, have a baby of their own. But she was also scared, and she had a lot of anxiety about the idea of making it through a pregnancy and making it through the early years of being a mom while struggling with really debilitating neck and back injuries. And that became a huge part of how we described her injuries, because it was really a huge part of her truth. When I asked her, just she and I talking, what's the worst thing? What's the biggest change, the biggest impact? She kept coming back to her young daughter and how she felt like an incomplete mom. And she had so many stories when I was able to finally pull them out of her. Not so much from the pregnancy, which she got through with not a terrible amount of difficulty, but from when her daughter was a baby and in a crib by the bedside in the middle of the night, crying, and she described in really intimate detail not being able to get out of the bed because her neck and back, she was all locked up and frozen and really struggling to get out of bed when her new baby was just feet away, crying in the bassinet, and how her husband would have to get up and pick up the baby, and that by the time she was able to struggle her way out of bed and get over to where they were, the baby was already in her husband's arms, and he was comforting her, and she had to sort of stand behind him and not have that physical connection, not have that primary connection. And there were so many stories like that in year 1 and year 2 and then year 3 of this early part of her daughter's life, where she described not being able to meet the demands of motherhood and feeling really incomplete as a mother. And that was all really central to her truth. And it was 100% legitimate. It came from her heart, and we helped her bring that out. We helped her tell that story in vivid detail. And it came across, as it should, in a really powerful way in the courtroom. And what we found out later is that really resonated for the jury, particularly those leaders who I mentioned, and particularly the parents on the jury. It was something that folks could identify with. And I was really proud that she was able to describe that effectively. And the thing that she told me privately was the biggest impact was something that she was able to communicate effectively in the courtroom, and it made a difference. And so that's when things really come together and truth and justice really align in a great way. And so that was a powerful ingredient in the verdict, and it was something that I was very happy to see she was able to describe during her testimony. In terms of the verdict itself, we were obviously gratified, especially going through a 3-week trial where we had fears that things weren't going our way. During deliberations, Ian, the jury sent out a number of notes, and it was only during deliberations, when those notes started coming, that we were able to see which direction the jury was going, which way the verdict was likely to go. And it was only when those notes started coming in deliberations when I realized, wow, we're in this to win, and we may win this case. And by the time, hours later, that the jury was filing out of the deliberating room to render their verdict, we didn't know, but we had a good, strong sense that we were going to win. But we didn't know how big. And then when the actual verdict came in, and it was a sizable and really just verdict for her substantial losses and impacts and harms, it was really gratifying. And it was one of those moments, my client was a Spanish speaker. She testified in the courtroom with an interpreter. And when the verdict came in, it was late in the afternoon, and she was sitting in the audience by herself. with nobody there to interpret. And so in real time as it was coming in, I was looking back at her to see whether she was able to understand that she had won the case. And so that was also a moment too.
And can you tell me how much the verdict was for?
The verdict was close to $5.9 million. It was 5.8, I think 7, but it was just under $5.9 million.
And what, in the end, what is the key to getting these types of verdicts?
The human story. Spending the time and doing the work to make sure that your client's human story gets through and isn't thwarted by the defense's attacks. You know, they do everything in their power to take the plaintiff down, to make her into a person that the jury is unwilling to listen to, unwilling to be open to, fighting that fight so that the jury is open to listening to your client, so that they don't hurt or destroy your client's integrity with misdirection and misinformation, and getting that human story out, which, you know, you have to find the story. And oftentimes with our clients, because they've suffered significant injuries and it's been a really tough road since the incident occurred, that human story, once you find it and you give them the wherewithal to tell it effectively and truthfully and completely, it's usually very powerful. But it's about finding the human story.
Awesome. Well, Steve, this has been fantastic. Thank you so much for joining us on True Law Stories and telling us the story of this incredible trial and path to helping this woman out. I really appreciate it.
Thank you so much. It was great to be with you, Ian. Great to see you as always.
Always, yes. And thank you all for watching us on True Law Stories and making us a part of your story. This has been Ian Garlic and True Law Stories.